Ladies and gentlemen, good afternoon. Welcome to American Law webinar series by Lehrmach. Lehrmach is an intellectual property rights consultancy. This is Leon, Uwe Lee. I am Lehrmach's legal counsel and your presentation host. Martha Stewart, the famed or infamous lady entrepreneur, is in the news, canvassing top cover page for Sports Illustrated swimsuit edition. Even more poignant, the fact that she is over 80 years old. Well, since Martha is in the news, decided to case brief her New York insider trading court case, specifically on federal assertion that she abandoned her attorney-client privilege when she communicated her attorney communique to her daughter via email. In American jurisprudence, in addition to established procedural law, as in written court procedures of what rights the litigants command in court before and during the trial, other foundational aspects of this tripartite jurisprudence are discovery and attorney-client privilege. Discovery is a unique American doctrine that you command the legal right to gather evidence to support your case, such as witnesses that will affirm your legal claim, but also relevant information in possession of your court opponent's party, such as email communiques, metadata from mobile devices, etc. Rounding out this jurisprudence foundation is attorney-client privilege, a confidentiality bedrock between the attorney and client on strategy to present its own court case. Any compulsory revelation of this confidentiality can and will unduly undermine or abrogate client's ability to access an impartial trial, since one's opponent party will know exactly the legal strategy to be leveraged in court and immediately formulate precise countermeasures even before commencement of a trial. Although state and federal courts command its own precise definition of this privilege, suffice it to state that all U.S. courts recognize privilege to encompass, number one, communication, be it verbal, written, or electronic. Number two, made between legal counsel and client. And number three, made in confidence for purpose of seeking or providing legal recommendations. That being stated, there are legally acknowledged exceptions, for you cannot tell your lawyer everything under the sun in confidence, especially pertaining to planning or intention of committing a crime, be it fraud, homicide, or other defined crimes. If this was the case, then by law, the client, through this action, expressly waived this client privilege. Attorney will then affirm that no such privilege now exists. Hence, law officials can legally interject and intercede these communications as non-privileged information for later prosecution. Whole mannerism is the old legal dictum that when coming before the court, you must come with clean hands. That is, you cannot use the legal system to legally perpetrate a crime. Thus, dovetailing back to our Martha Stewart case, this is the trajectory of argument from federal officials as they attempt to sever this attorney-client privilege. Hence, let us begin.